The High Court has struck down rules and guidelines for the operations of Section 17.2 of the TCP, directing that any proposals which come have to be considered in the light of the RP only and not independently, not by themselves, not for reasons of inconsistencies and incoherency, Petitioner's counsel Norma Alvarez said after the judgment. The court order came in the petitions filed in this regards by several organizations and individuals. The court has said that no further approvals can be granted at present when the state government sought a stay of the operation of Section 17.2 for 6 weeks, she said. The court has placed the matter after 6 weeks.
The court has just delivered its judgment on the challenge that the petitioner, the Goa Foundation, and several other petitioners made to the validity of Section 17.2. And the court has struck down the rules and the guidelines which enable the operation of Section 17.2. As regards the 17.2 itself, it has decided that the 17.2 has to be read down, which means that any proposals which come have to be considered in the light of the regional plan only and not independently, not by themselves, not for reasons of inconsistency and incoherency. Good victory for people, because we were opposed to the zonings which were being changed bit by bit, spot by spot in different places, changing the entire context of the landscape of Goa and literally casting aside the Regional Plan 2021, which is still valid and holds good for the people of Goa, protecting its ecology and environment while also allowing for development in certain areas.
When asked about the future of conversions made thus far using provisions under 17.2, Advocate Norma said that error has to be shown vis-a-vis the original proposal in the regional plan. So each of the approvals that have been granted zone change permissions will have to be reconsidered in the light of what they were in the original regional plan, and only if they can show that there was some error in the regional plan, then only a change could be considered. The PIHAL had challenged the first 24 change of zone approvals.
The court has placed the matter after 6 weeks, so we will have to read the judgment and consider each individual case, because many cases were done on the basis of inconsistency and incoherency and not error. Error has to be shown vis-a-vis the original proposal in the regional plan. So each of the approvals that have been granted have to be considered, to my mind, reconsidered in the light of what they were in the original regional plan, and only if they can show that there was some error in the regional plan, then a zone can be a good zone change could be considered, not because people find that this is not a correct zone or this is not a good zone or I want to develop my property. That is all cancelled by the High Court. It is not disposed of. It will be listed after 6 weeks. We had challenged the first 24 approvals, zone change approvals which had been granted. We will have to read that and find out how they are. But to my mind, most of them was spot zoning, which the court has said should not be done. You can't change plots spot by spot, piece by piece in the regional plan. That is not permitted from our reading of the court's declaration in its judgment.
3 environmental organizations, including the Goa Foundation, the Kazan Society of Goa, and the Goa Bachao Abhiyan, as well as some individuals, had challenged the provisions under Section 17.2. Omkar Deshprabhu and Vincent Rosario for GOA365.